Good afternoon, everyone, and welcome back to this afternoon's session. My name is Megan Norris, and I'm a solicitor advocate at Legal Aid. This afternoon's session is Lesson from the Trenches, Safety Planning for Lawyers. I'd like to introduce our speaker this afternoon, Dr. Brent Waters. Dr. Waters is a child and adolescent psychiatrist who will be familiar to many, if not all of you. Dr. Waters works in private practice, mostly assessing children and their families for the Family Court and the Children's Court. He has a particular interest in developmental paediatrics, psychosomatic illness, coping with chronic and terminal illness, non-physical abuse and neglect of children, child welfare and forensic medicine. Dr. Waters, thank you.
Thanks very much, Megan. I'd have to say this is the first time I've been asked about safety planning for lawyers. When I came back to Australia from Canada, where I worked in the similar role in the Family Court in Canada, who had a very similar act to the Australian one, everyone was focusing on safety planning for judges because there'd been some very bad incidents in the family court, including some deaths. So I think while this is a subject which I'm sure within in-house has always existed, I think it's really important that it's being addressed in a more formal way now. And that's going to be one of the things that I'll talk about, not just a bit about what happens, but what I think needs to happen to keep lawyers safe in this very difficult jurisdiction. I'll see whether there we go. Okay. I'm just going to check because this thing doesn't seem to be changing the slides over. Not that that especially bothers me. Let's go without it. That's all right. Now, let me just quickly. Let me just quickly talk about what I call unsafe litigants. So, just for the purposes of today. These are people who basically are dangerous for one reason or another. And danger sorts itself, at least in the family court cases that I've seen over the years, into two distinct but also often overlapping forms. The first is threats of physical violence of one sort or another. And the second is stalking type behaviour. As I say, they overlap a lot because a lot of people who stalk are also fundamentally quite violent, but by no means all of them. A lot of them are quite sinister, whereas there's a group of violent people who are just plain impulsive, aggressive and impulsive. One of the basic thing which lies, I think, behind most litigants who would regard as unsafe is that they've got a strong sense of grievance. And the interesting thing about them is that most of them have had a strong grievance for a lot of their lives. But now they're thrown into a conflict situation in the family court. In fact, sometimes the reason that these matters haven't been resolved, in fact, often I think the reason that matters haven't been resolved in the family court is because of their abiding sense of grievance, and it's now around the subject of the breakup of their family. There's a strong, certainly in my experience, there's a strong gender trend with people who are unsafe. It's particularly the ones who are physically unsafe and who are likely to be most persistent. They tend to be men, not all of them. And the sorts of things that you see commonly in them is intimidation, stalking, threats, and physical violence itself. Among women, firstly, they deal with grievance in a different way, and by and large in a much healthier way, of course. But still, some of them can be very difficult. So they can also stalk in their own way. But they also tend to use complaints mechanisms. They tend, in a sense, to be more law-abiding in a way. They'll tend to use the regulatory authorities like the Medical Board or APRA or something of that sort. I'll come back to that in a minute, but The next thing I just wanted to raise is that in many areas of many occupational areas, safety has been on the agenda for a long time, and there are formal structures to protect people working in that particular workplace, everywhere from the construction industry down. I'm not sure how well embedded that is within within family law practice, and so I wanted to have a bit of I wanted to talk a little bit about some of the things that one might think about if in fact it isn't all that well embedded. The first thing is that that it's really, because these people are quite dangerous, but often difficult to pin down, if I could say. It's often hard to put a name to them, except usually that they're unpleasant, or that you feel a bit scared of them, or something of that sort. It's important to see it in your workplace as an occupational health and safety issue. And it's just as important as any other occupational health and safety issue that applies to your workplace, but most of them that you normally work under and with actually don't relate at all to your clients or people who come along as baggage with the clients. The second thing is that it is also a law and order issue. These people do illegal things. You're lawyers, and one of the things that astonishes me actually is a degree of timidity about doing the sorts of things that you know you can do much better than me as a non-lawyer. So I just wanted to briefly touch on that as well. And the third thing that's related to this is that, and I think which complicates it, is that it raises the dangerous clients and dangerous people associated with your clients raise a bunch of ethical issues and duty of care sort of issues, which are sometimes not really, sometimes sort of fade into the background a little bit when you think about being endangered. You sort of get a bit of cabin fever in a way. You sort of feel you feel besieged, so you tend not to think of all the issues. And so what I'm going to talk about a little bit later is about how one can make sure that one thinks clearly about these issues, because clarity early on is really important. Okay, now I'm just going to quickly touch on a couple. Touch on a little bit about how you can predict risk. There's been a certain amount of research in this area, and unfortunately, it's not terribly helpful. If you look at correlates of violence and correlates of threats to lawyers and various other people in the community by people who are involved in family court legislation, the data doesn't really show anything that's terribly surprising in the sense that it's related to social class and level of education, but even then it's not a strong association. And more particularly, it doesn't say anything specific. So all I can talk about really is what my experience has been over the years. The sorts of things that worry me when I see them in a person who I think is going to be a risk is a history of aggression, of violence, a history of coercive control in particular, a person who's very impatient, although some of these people are not impatient at all, they're extraordinarily patient, particularly stalkers, and people who are obsessive and vexatious. One of the things that always bothers me is when you see annexures to the affidavits that have got all kinds of marginal comments on them. It's got an obsessive mind working, but the vexatiousness is a particular issue, and people who never take responsibility, it's always somebody else's fault, and in the case of their lawyer, it'll be the lawyer. And behind this often is usually some sense of insecure self-esteem, although usually they're so well armoured you don't see it. And some of them are just patently lonely. So let me first talk about the situation where you've got an angry client. Now, in some respects, the angry client is much easier to manage than the stalking client or the stalking family court participant, because there are a number of things that you can do to try to de-escalate anger in a client. You listen a little bit more, you try to get them to focus on the issue and solution focuses, one of the other things too is don't let them stand up. It's really interesting what effect it has if you are seated at the same level as the person, preferably not behind a desk, so there isn't a perceived power hierarchy. And people are also more placid when they're seated. So you try to seat them. I mean, they may seem terribly trite and silly things, but they're quite important. But if that doesn't work, if those sort of social techniques don't work with angry clients, then you need to start to think about whether this is going to turn out to be a more serious problem, particularly if your attempts to maintain personal and professional boundaries are constantly being thwarted and penetrated. And you also, with people like this, you need to start to be vigilant about whether there's other extraneous behaviour going along, like stalking, which I'll talk about a little bit later. And at that point, you should already be starting to think about whether you're going to need to upscale the way you respond to the situation. Now, I'll come back to some of these things a little bit later. With non-client anger, so you're talking about a parent, for instance, if you're an ICL, if you're starting to get angry behaviour directed directly towards you, or various other inferential sort of stalking sort of behaviours, you don't wait until it gets worse. It's really important that you share your story with somebody. And that's one of the things I want to come back to, is the importance of a mechanism for practitioners to be able to talk through a situation which they think is starting to escalate or could get worse, with a peer or a mentor or somebody within management, particularly somebody who's had a similar, or at least who's a practitioner themselves. Okay, now stalking. Interesting. There's always been stalkers. There are stories of stalkers that go back hundreds and hundreds of years that are documented in the courts. But modern life, and particularly electronic technology of a variety of sorts, both technology that involves communication with people and technology which involves the capacity to record what people are doing in their life privately, to secretly record people, and social media, I think has led to an increase in stalking. And the sort of things that you need, in the case that you'll be hearing about a little bit later on, the sort of things that you're looking for, all those things in there, but particularly if there seems to be some implied threat, if you feel as if you're being harassed, if this person is making unnecessary and unwanted contact with you, if they clearly know things about you that you haven't disclosed to them. And sometimes, oddly enough, these people can alternate between being rather unctuous and over-familiar with you, and at other times visibly annoyed and implied threats and that kinds of thing. Sorry, I think I forgot to turn that slide over. Okay, well I'll just work off my. Oh, here we go. It's got a lag time like a senile old man like me, not an electronic device. Okay, so I've done that one. We'll see how long it takes to. Good. Okay. Now, interestingly, Australia has been a bit of a centre of research into stalkers. A guy called Paul Mullen down in Melbourne, who's a forensic psychiatrist, and he's done a subtyping of stalkers. He studied hundreds and hundreds of them. None of the categories that he has really fit the ones you see in the family court all that well. Probably what he calls the rejecting stalkers, the ones who feel rejected, is the nearest thing. And these are people who they perceive rejection, a failure for you to get a result from the court, a failure of their wife to do whatever they wanted in the relationship, failures all around them. They're, as I say, they're these sort of people who alternate between sometimes wanting to win back favour with you if it's one of your clients, and other times can be quite cranky with you. The behaviour seems to be maintained because it makes them feel better about themselves. They feel as if they're in the driver's seat again. They feel in charge. It's significantly a control issue that goes across all of the forms of stalkers. I've put a link there to some of the research in the area, but I won't really dwell on that too much. Let you look that up. Now, managing stalking, as I said before, the important thing is don't wait. It costs you nothing to talk with someone within management or one of your peers or mentors. And having had that discussion, if you feel that this is a stalking issue, you upscale your response to it immediately. The principle with stalkers is don't keep it secret. In stalking in any context, don't keep it secret. They hate the light of day. You've got to remember that. Okay, sorry, I'm not keeping up with my slides here. Now, in terms of upscaling, there are a few things that are important. The first thing, as I say, is don't blame yourself. People often feel either they did something wrong, or they haven't done as well as they could have for the client, or in some way or other the stalker almost gets them into the sense of blaming themselves. So that's really important. You've got to get your mindset right. This is not me, it is him. The second thing is you must have no contact with them. Once you've decided, once it's clear and your colleagues reinforce or confirm that this is a stalking situation, or that it's so high on the scale that it needs to be investigated as a stalking situation, you stop any contact with them. Any contact with them after that needs to come through a third party, particularly somebody who has an air of authority about them. It may be the police, it may be the head of the LAC, or you try to keep contact as much as and not respond to them as much as you possibly can. But where it is necessary, make it official. I've mentioned about consulting early with managers and mentors. With stalking, once it's clear it is a stalking situation, then, as I say, I think that brings it into an occupational health and safety situation. And once you get into that area, you need to that's where you've got to put your lawyer hat on and start thinking about whether this represents a breach of the law in relation to stalking or in relation to domestic violence. Of course, that's an important part of the mentoring mechanism as well. I'll come back a little bit to that in a second, if I can get past this one. Oh, sorry, I'll go back. Now, one of the things that you also need to think about if you're in a situation like that is that it's not just your safety you're talking about. If you're an ICL, and even if you're representing one of the parties, I suspect, there's not just the personal concern that one has, but there's the mandatory child protection reporting, and ICLs are also mandatory reporters. Now, let me just quickly touch on a couple of the vexing sort of ethical and professional sort of dilemmas that you run into. You've got a number of duties. You've got a duty to a client, you've got a duty to the court, You've got a duty to the child if you're a mandatory reporter, and you've also got a duty to yourself and your family. And it's really important that you think about each of these ones when you're considering and consulting with colleagues about what's the best way to proceed forward, because it's easy to forget about one part of that, and a part of the mentoring process and the internal process should be to consider all of those things in a systematic way. Now, in terms of how this can happen within an organisation like the Legal Aid Commission, once things get to the point where you're scared or you're worried, let's say, that's a better word, you can probably have two levels. The first one is a less formal situation where you're able to have a talk with a peer or management about the issue, about whether it gets to a certain threshold, that kind of thing. And the second is upgrading it from there to an occupational health and safety process. And at both levels, it's important, but particularly the first one, it's important to look at the safety issues and also to look at the conflicts of responsibility. Once you get into the OH&S area, it's probably at a level where you're looking at more structured sort of intervention. Now, just to finish, I guess legal aid is large enough and it's got a diverse enough staff that having a peer review, mentoring sort of process is easy enough to have in-house. And also you've got experts in some of the areas of dangerous, like people in the criminal jurisdiction who work in the criminal jurisdiction and that sort of thing, and people who work with domestic violence a lot. But a problem is what about panel lawyers, people who are not working within an organisation like that. Some of them work in large enough firms that they've got mechanisms of this sort, but a lot of them don't. And so I think that one thing needs to be considered, particularly for ICLs, is whether legal aid can open up its own structure to provide panel lawyers who don't work in large firms with that same sort of support. So thank you very much.
Thank you, Dr. Waters, for that presentation. Certainly some important strategies and safety planning ideas for lawyers to take away today. We will shortly be joined by an online panel to discuss a scenario to showcase some ideas how to practically safety plan. We'll be back in a moment. Thank you, everyone. We're now joined by an online panel and myself and Dr. Waters in person. I'd just like to quickly introduce our panel. We have Dr. Waters, we have myself, we've got Anna online there. Hi, Anna. Anna is our solicitor in charge of the Legal Aid Domestic Violence Unit. Anna is an accredited specialist in family law and an independent children's lawyer. Anna has an extensive experience in complex matters and litigation involving families affected by domestic and family violence. Francis is also online with us today. Francis is the solicitor in charge of the Sydney Central litigation practice. Francis has experience representing both parents and children in Sydney in Parramatta, in both the Family Court and the Children's Court. And we're also joined by Lisa Dawson. Lisa is the solicitor in charge of Grant's family. Lisa joined Legal Aid in 2007 and previously worked in Gosford, Nowra and the Parramatta office. Panel, I have a scenario that raises a number of issues about safety planning for lawyers. And so I'm going to read out the scenario and I'm going to throw to the panel just to give us some tips and tricks, perhaps implementing a little bit of what Dr. Waters has touched on before, just so we can look at those issues. So this is a scenario where you are the independent children's lawyer for Bobby, who's 10, and Betty, who's 4. You file your notice of address for service from the generic office email address. Not even 10 minutes after you file your notice, someone by the name of John Smith is calling the office and telling your receptionist that he urgently needs to speak to you. You're about to dial into a Teams mention and your receptionist tells Mr. Smith that you're unavailable. During the Teams mention, you are sent a number of messages from reception informing you that Mr. Smith has dialed in another 6 times. And you can see from your emails, he's also emailed your personal email address about 3 or 4 times. He has demanded that you return his call and return those emails by close of business today, or there will be consequences. Anna, I'm going to start with you if I can. What behaviours of Mr. Smith cause you some concern, and what would you do about those behaviours?
Thanks, Megan. And thanks, Brent. I could have listened to you all afternoon. I guess at this stage, I'm unclear whether I've seen any of the court documents or other materials, but there's certainly some red flags that are coming up for me, and I'm starting to get that gut feeling about Mr. Smith. The things that are giving me those concerns are things like the almost immediate contact after filing my notice of address, the repeated calls, the escalation from calling to emails when he doesn't get the response that he wants, the escalation to emailing my personal email address that isn't on my notice of address for service, and of course then there's that threat. At this stage, I don't really know what that threat means. Is it something about my role as the ICL in the proceedings? Will he bring an application to say I need to be dismissed because I'm not responsive? Or is it something more pointed and targeted at my personal safety? I guess I just wanted to flag that risk assessment and safety planning can be very nuanced, and there can be a real fine line between setting boundaries and triggering future events. So I'd want to be careful at these initial stages in how I respond to Mr. Smith. And I also want to flag that undertaking risk assessment and safety planning is something that comes as second nature to most of us when it comes to when we're dealing with our clients, but less so when we're dealing with ourselves. But it is something that we need to think about. We need to remember it's a process, not a one-off at the start of the litigation or our role in the proceedings, and something that we should continue to revisit. So things that I might do, I would try and contact him, listen, try de-escalate, see if it is just something I could manage because it's initial anger or outburst, and I would try and set those clear boundaries. There are some other practical things that I would think about. If I'm working from home and using my personal mobile, making sure that my mobile telephone number is set to not display on outgoing telephone calls. If needed, I can block his email to my personal work email, or set some boundaries and rules in Outlook around what that might look like. I would flag my concerns with my manager or someone else that I could speak to about that. And I'd also have a discussion with the staff in my office who are the front line in dealing with Mr. Smith. And I would give them some strategies on dealing with him and offer them support. And I could even offer them a script of what to say when he calls. And finally, I would start thinking about the future and planning my future responses, and think about whether I needed to have a debrief and what other support I might need at this stage.
Thanks, Anna, and I noticed you're getting a lot of nods there from Dr. Waters, so I think we're on that right track for safety planning. All right, so the next day, John Smith comes to your office with a box of documents and demands to see you in person. Your receptionist tells Mr. Smith that you're not in the office and you're working from home. Mr. Smith comments on the physical appearance of your receptionist, calls her some names, says to her she's a heartless cow. Eventually he leaves, but he sits himself on the park bench across the road for at least an hour. Later that day, he sends you an email that says something like, "I need to speak to you," capital letters for the need. "Don't ignore me. This is about my children. I know you have children too. I will come back tomorrow and keep coming back to your office every day. You can't hide from me." Mr. Smith does not include the mother's lawyer in his email to you. You have a quick look at the court documents and you notice there are a lot of USBs marked in red pen, distressing material. You also notice that there was an AVO for the mother's protection from Mr. Smith, but it's now expired. You have a look at the mother's notice of risk. It alleges that Mr. Smith has some mental health issues, took explicit photos of her, used physical discipline on the children, kicked the family dog and filmed himself doing it, has threatened self-harm if the mother didn't reply immediately to his text messages, has tracked her on his mobile phone and has isolated her from friends and family. Frances, there's a bit of issues there for you to unpack and consider. I'm just going to ask for you to give us some strategies or examples about how you would manage this escalating behaviour of Mr. Smith. And could you give us some steps or what you would do in relation to that USB material that's marked distressing?
Sure. Thanks, Megan. I suppose what I would firstly say is I'd reiterate what Anna said in relation to setting professional ground rules and limits, and set safe limits and start as you mean to go forward. Things like sending emails only from a central email address rather than your own personal email address, not providing a direct phone number for litigants to call you on, using the delay send function in your emails to ensure that you only send emails within business hours so that you create a very clear professional boundary that makes your relationship with the self-represented litigant clear and unambiguous. It's important that you ensure that all your communication is to both parties. Sometimes in the heat of things we forget, but we need to make sure that if one party emails you, that you reply and CC the other side with a reminder again to the self-represented litigant as to what is expected, what's considered appropriate and what is professional and respectful behaviour. And that's an important thing, continuing to reinforce the boundaries and the guidelines that you set as far as your professional relationship is concerned. Just always to remember that we also continue to clearly communicate to both parties all issues in relation to the decisions we're making to represent children. Sometimes, again, we might communicate what we think is very limited issues or timetabling issues to one parent rather than the other, which can create inadvertently a perception in the other parent that they're being left out. If we maintain and continue to remember those rules, that will assist. But moving on to the escalation, I think the first issue in relation to his attendance at the office, that is obviously a serious issue for which that you would be assessing the risk, speaking to your staff and making an assessment at that stage whether the behaviour is seriously impacting the officer's capacity to provide service delivery. I would say that within legal aid we're very good at that. We have a lot of a good framework for that to escalate to managers to discuss those issues, but it's certainly an issue to address with your staff to make sure they're okay. To the father, I would, after that incident, be very clear to again reinforce the boundaries and the expectations following his attendance at our offices. I'm very interested in Brent's comment that stalkers in particular don't like the daylight and that that really reinforces to me the decision to say to him very clearly and to the other side that his behaviour in attending the offices and behaving as he did was unacceptable and inappropriate, and to be very clear to him that in the event it occurs again, that further action might be taken to restrict his access. I just think we have to come out really clearly and be very, very certain as to what we think is expected. Briefly, the comment, "I know you have children too," is obviously an enormous red flag for any independent children's lawyer. It's an indication potentially that this self-represented litigant has done some level of searching in relation to our personal lives, and that's something that obviously deserves some further investigation to give some consideration as to whether or not it's an offhand comment or whether there could be more to it. And I know that as the scenario unfolds, we'll come back to that issue and how to protect ourselves as far as social media is concerned. Briefly, as far as the USB material is concerned, obviously, again, exposing both ourselves, our colleagues and our support staff to distressing this material is a real and significant issue for us, and we need to always ensure that we minimise that exposure unless necessary. We need to bring in place supports to debrief, as Brent mentioned, to debrief with peers, with managers and with other ICLs who have similar experiences. One thing I would say about the USB material is, firstly, consider whether you have to look at it at this point. I would want to know, is it connected to anything that's filed? Is it annexed? Is it an annexure or a tender? Is it genuinely something that is part of the proceedings that I need to look at? If it's not, then again, I would be communicating to both the father and the mother to acknowledge the material and to indicate my intention at this stage not to view the material unless it's considered that I need to. Thanks, Megan.
Thanks, Frances. Okay, we move on. On Sunday morning, you're off for a walk and you stop off at your usual coffee shop. You think you can see Mr. Smith sitting across the road in a car taking photos of you. You start to walk towards the car to try and get a closer look, but when he spots you, he speeds off. You don't tell anyone from the office about the incident because you're worried you're just paranoid. The interim hearing in this matter is on Monday on Teams. You're appearing from your home office. You dial in, but you forget to blur your background. Mr. Smith, the mother, and her lawyer are all in the virtual courtroom as well. Mr. Smith immediately comments on that landmark view outside your window. He then comments that your red lipstick is over the top and it's not a nightclub, it's a courtroom. He also says, you should have just worn your active wear to court. When the judge enters the virtual courtroom, Mr. Smith is on his best behaviour. You think that Mr. Smith has recorded the interim hearing because you can see him fiddling with a dictaphone or an iPhone. You also saw him point his camera at the phone, at the computer screen, and you're pretty sure he was taking photos of you. Anna, I'm going to go to you again. What would you do in these circumstances? And can you give some examples of how or what safety planning the lawyer might consider necessary at this stage?
Thanks, Megan. There's probably two stages of things that I would do at this. An immediate response while I'm in that Teams interim hearing is just ask the judge to remind the parties that they can't record the proceedings, particularly because there's a self-represented litigant. And then I would think about what I do with my other concerns after the interim hearing has concluded. And after the interim hearing, I would again return to safety planning and risk assessment. And Frances, please always feel free to jump in if you have some other suggestions as well. But there are a few practical things I might consider. I might consider changing the physical setup of my home office if that is at all possible. For me, I have limited space, so I'm a bit stuck in how my home office is set up. But for some people, you might be able to rearrange things so that what is behind you is unidentifiable. I'd also look at changing the settings on Teams so that my background is automatically blurred when I went in, and think about changing what my name says when I'm entering into the Teams room. So change it from Anna Boltons to independent children's lawyer or something like that. I would consider other practical things like referrals and future orders. Has Mr. Smith been engaged with the FAS Social Support Service for Men, a service that can speak to him, spend time with him, help de-escalate, provide appropriate referrals? And it is a men's service, and hopefully that would be something that he would take up if he hasn't already been referred to them. Men's behaviour change programs, assessments, things like could future court events be changed from the Teams forum into a telephone mention? I would speak to my manager and colleagues about a number of things. Firstly, I need to make sure that people know what happened on the weekend, and that I wasn't just being paranoid. I need to raise my concerns, and I need to raise those concerns in the context of, does this need to be reported to the police or escalated further? I need to think about strategies for my personal safety at work, at home, changing the routes that I go if necessary, consider a personal duress alarm or app on my mobile phone, look at the security measures I have at home and at the office. I need to think about the future conduct of the proceedings, including whether I continue to act or someone else in the practice assumes carriage of the matter, or whether other lawyers can mention the matter for me, or I can have agents appear at different stages so it's not only me appearing each time. And I need to think about a more structured safety plan moving forward. And I also need to think about strategies for my own self-care. He's made personal attacks on me. I'm feeling stalked. I'm feeling that he's knowing too much. Do I need to contact the Law Society's SOS team? Do I need to contact my EAPS provider, engage with my GP or other support networks as well? Mentors, colleagues, but making sure that I have that professional debriefing and that support for myself too.
Thanks, Anna. Okay, I want everyone to consider for a moment that we're acting for Mr. Smith. About a week before the interim hearing, the ICL tells you that you'll be seeking orders for Mr. Smith to spend supervised time with the kids. You are not sure how to tell your client about this, and you're worried about how he will react. You decide it's best to meet with Mr. Smith in person to explain the ICL's position. Mr. Smith tells you he can only get to your office at 4:30 on a Friday and that he'll probably be running late. At the meeting, Mr. Smith turns up closer to 5 p.m. There is only one other colleague in the office. You warn your colleague that Mr. Smith can get a bit heated, but you're pretty sure that you can handle him. You tell Mr. Smith about the ICL's proposal for the upcoming interim hearing. In response, Mr. Smith's behaviour escalates to a point that you've never seen it before. He starts swearing and screaming, and he stands up over the top of you. He screams at you, "This is all your fault. You didn't draft the affidavit the way I told you to do it. I should just end my life now. It's not worth living without my kids. You're the worst lawyer in the world, and I'm going to make you pay for this." Lisa, I'm going to go over to you from a grant's perspective. If a lawyer has concerns about their safety, can you identify some options available to them from that grant's perspective? And what information would you need practitioners to provide for those options to be considered?
Certainly. Thanks, Megan, and thanks, Brent. I'm hoping that I might be able to address the comment that Brent made towards the end, is where in relation to whether or not legal aid is open to a structure in relation to panel practitioners and providing them with some sort of support in these sorts of situations. Certainly, I think that if a lawyer has concerns about their safety, in particular the sorts of circumstances that we've identified today, that there are options that are available to them. The panel practitioners should know that grants can work with the panel practitioners if this sort of situation arises. Usually these sorts of matters are file managed by a senior solicitor within the grants family team. And effectively what that means is that that particular grants practitioner is familiar with the situation, and any extension that is submitted by the practitioner goes direct to that the same grant solicitor. So it's not going into the work pool. There is a one point of contact, for want of a better word. We also do, in these sorts of situations, provide additional funding. Anna mentioned previously in relation to having an agent help out so that there is someone different at each court appearance. Certainly, we're in a position to be able to provide additional funding to practitioners who do find themselves in this sort of situation where their safety is compromised, and we can work with them to assist them in relation to giving them an additional grant of aid to engage counsel when they are needing to appear at different mentions and court events. There is also the option to transfer the matter. Ideally, not anyone's first point of contact, but there's certainly some situations that have arisen where this has been necessary. I think everyone would like to try and avoid it if at all possible, but certainly the option is there. Care needs to be had, especially from our perspective in relation to referring this matter to the next incoming practitioner, because obviously it's not sort of matter that we would put out to the panel to just allow someone to pick up that matter. There's certainly lots of conversations that would be had with the practitioner who is saying they're unable to act in the matter anymore for whatever reason, and then quite lengthy conversations with the practitioner who we may be warm referring that matter to. And those conversations would also involve how we can assist them. So the sorts of things that I've gone through, that I just went through, we certainly have those practitioners with the incoming practitioner, because we want to, we obviously want to ensure that our practitioners are safe, our panel practitioners are safe. We acknowledge that we call, legal aid calls on our practitioners all the time in so many situations. We certainly value the work that our panel practitioners do for us, and we certainly wouldn't want to lump them with these sorts of matters, walk away and wipe our hands of it and say, you know what, it's yours now. So please reach out. The support within grants is definitely there. Information in relation to what practitioners need to provide for this sort of approach to be considered is probably, in the first instance, just some submissions from the practitioner. Reach out to us. Let us know specifically what those issues are. Identify the concerns that you have in relation to your own personal safety. Provide us with any safety plan that is in place. But certainly, if we know what the issues are, then we know how we're able to work with you. So specifically identifying what those sorts of things that both Anna and Frances have gone through, that will assist us in how we're then able to better help you.
Thank you, Lisa. Okay, we're putting that ICL hat back on. The judge makes the orders proposed by you. Later that night, you receive a high volume of angry emails, and they get worse and worse as the night goes on. His language is abusive and aggressive. Mr. Smith is now threatening you, your staff, and your family. The last email is sent by him at 4:10 in the morning, and it says, "Watch your back, you will pay for this." You are starting to feel really exhausted from the constant communication you are receiving from Mr. Smith. As well as the constant emails, someone called Johnny Smith D has started contacting you on Facebook. This is despite you clearly using your middle name instead of your last name. Johnny Smith is sending you abusive messages that they will get you, and is also commenting on photos of your kids. It seems to be a fake account, and you suspect that it is Mr. Smith. Frances, I'm going to come back to you. How do we safety plan in relation to electronic communication? And can you give any tips about social media and our personal presence on social media?
Sure. I think the first thing I would want to say is that I acknowledge entirely that from personal experience, this style of communication is simply exhausting. And so to every practitioner that has experienced this, I am with you. It is really hard, and nobody minimises the personal impact it has on lawyers to get these emails in the morning, which are so many overnight, sent in this barrage, this machine gun barrage. I come back again to really making sure before we hit the switch in relation to some serious things that need to be brought into place to protect the practitioner. Coming back again to making sure that you're maintaining the boundaries that you need to maintain in relation to non-personal email addresses, making sure that perhaps as a very easy rule is to have a rule in relation to that particular parent's email that it automatically goes into a separate inbox from your general inbox, so that you can make your own personal decision to perhaps once a day or twice a day check that mailbox, that particular folder, to show you what emails have come in. It can help you personally manage what feels like a tsunami of attacks. At this point in time, I think this particular dad is, we have got to the stage where we're presuming we've told him before about minimising his communication, maintaining a professional demeanour, limiting communications within business hours, that we won't respond within business hours, and it's been to no avail. The next step absolutely is going to be that I would imagine we would make a decision, and this would be done within legal aid at a manager level, at director level, that we would no longer accept email communication from this individual. And that's a reasonable perspective to take. In these really difficult matters, it's entirely acceptable to say, no, you're blocked. No more emails, and this is how you communicate with us from now on, and providing essentially a snail mail address. If we've made a decision that we will continue to represent the children or child, maintain our independent children lawyer status, but we want to ensure the safety of our staff, that is probably the next step that you would be considering. You are obviously considering at this stage whether or not the material what has happened warrants a report to the police. I would pick up on one aspect of, Brent mentioned ICLs being mandatory reporters. We're not mandatory reporters, but what we have an obligation to consider particularly the threats that are made, and to go through the risk tree that's available on the Department of Communities and Justice website, to assess risk issues and whether or not it is indeed appropriate as part of our role to file a notice of serious risk of harm. It could very well be that we're at that stage with the information that's happened to date, but we need to assess that. I absolutely, Lisa's comments about how grants can support panel practitioners in relation to representation. When we get to this stage, I think the anonymising, either formally or casually, of the independent children's lawyer becomes super important. And that's when we start to think about whether we use other practitioners and counsel to appear at court events, whether we, as Anna said, in a Teams event, court event, change our names to say not our names, but rather our role. And that applies to the communication that we enter into with the father, the court, the parties, that emails come from one space that is anonymised. It is just family legal aid or whatever the decision has been made, and that it is signed independent children's lawyer, not necessarily your name. Those are options that are available to anonymise the role of the independent children's lawyer in the absolute most serious of cases, but it is there as an option. Megan, I thought I was gonna leave Anna to chat about our social media platforms. Am I right?
Yeah, Anna, do you have anything to add? I mean, I've got a few tips and tricks, but Anna, what sort of things come to mind for you?
I think it's a great reminder that we need to quickly review our privacy settings on social media, and that we need to continue to do that.
Yeah.
Make sure that things like your photos aren't visible to the public, that your profile is locked down as best it can be. Check whether people can automatically tag you in check-ins, events, photos, or whether that needs your approval. Consider what you want to share online and have discussions with family and friends around those boundaries. For example, not sharing photos of your children in their school uniform that shows what school they go to and that then discloses the area you live. And remember not to link to your personal social media account from any office or business account as well. And don't forget, you can block people too. So those are just a couple of my very quick tips.
Thanks, Anna. Okay, the final stage of the scenario. The parties and the children are off to be interviewed by the expert. The interviews are conducted, and straight afterwards, the expert rings you and raises some concerns with you about Mr. Smith and about your personal safety as the ICL. The expert is considering making a mandatory report. The expert tells you that Mr. Smith made comments that he has installed a surveillance device in a teddy bear that he gifted to Betty at supervised contact last weekend. He also made a number of threatening comments about you. The expert tells you he's going to recommend that the report be released in person with all parties attending court for this to occur. You are starting to think you can't be the ICL anymore, and you certainly don't think you can do it alone. You've got approval from grants to have counsel come along with you on the day, but you're still worried about personally attending. You think it might be a good idea to contact the court and ask for a safety plan to be implemented for your personal safety. Dr. Waters, I'm going to come to you for the final question. From the perspective of the expert, can you give some insight about managing our personal safety around release of reports in circumstances like these? And from the expert's perspective, what sort of things would you do in terms of safety planning, not only for the lawyer, but perhaps the children in this scenario?
Well, in terms of releasing the report in the court, I mean that's something which one does reluctantly, because you like to give people the opportunity to think about what's in the report before they've got to face the judge. But if you're concerned about how the person may react to the report, then it's one of the things that one can do to sort of manage what could become a volatile situation. And in terms of the practitioner themselves, if I thought that the information had been provided, as you say, about the bugging the teddy bear and things like that, I probably would write a letter to the court and tell them what's happened, and that I'm having examined Mr. So-and-so, and bearing in mind what I knew then and what I now know, that I'd be very concerned. I'd probably say particularly about the ICL safety, but I might also, depending on the case, there may also be references to the safety of the children and the safety of the other parent as well. So I've got that mechanism. Again, it's in the service of putting it out in the open, and documenting what you know. In terms of the children, if there's a concern about the welfare of the children, then and particularly if you're thinking about flipping residency, then, and of course obviously people don't know that because they haven't read your report yet, what I would normally do under those circumstances is get the children brought to what used to be the family court counselling service for the proceedings that day.
So I certainly, thank you, Dr. Waters. I know from my experience, certainly when you get that email saying, from Chambers saying a report's going to be released in person and could the children please be brought to the registry, that's obviously some warning signs as the independent children's lawyer that something's going to happen. Francis, Anna, Lisa, is there anything from your perspective? I think that's quite helpful what Dr. Waters has said about what he would do. I guess looking at us from the ICL, I've mentioned that safety planning with the court. You might also, Anna, I think you touched on some social workers being available for the parents. Is there anything else, any other tips that either of you want to recommend in that scenario? I've got mute Francis laughing at me, so I'll take that as a no. That's okay.
No, sorry. I would merely, if I've got that email from the court that's told me that the report's going to be released, I perhaps would, firstly be trying to have a brief discussion with the single expert to try to get an understanding about what in particular I might need to be concerned about and what might be the issues that I need to address. And then, yes, if this is a personal, not a Microsoft Teams, because the pandemic has ended,
Fingers crossed.
then I would definitely be discussing with the court safety planning for myself, and I might not even be attending. If things have got to this stage, it might very well be the kind of matter where someone is attending on my behalf and as my agent.
Thank you. Anna, anything else you'd like to add?
I just echo what you and Francis have said, Megan, but you're right. The FAS social support workers are available and can be called on when reports are being released in person. So always keep that up your sleeve. If the parties haven't been referred to those social support workers, they're available for self-represented litigants, litigants with a grant of legal aid, represented by a private practitioner, pro bono or a CLC. So they're available to anyone. There's no means merit test for those social support workers. So if you're not sure about how to contact them, just reach out to the Family Violence Law Help website that has all the contact details for your local FAS, or contact the court registry.
Thank you. Well, that brings our session to an end this afternoon. So thank you very much, panel. Thank you, Dr. Waters. I wish everyone well in having some thoughts about safety planning for their future as we continue to do the work that we do. Thank you.